On July 1, 2024, a courtroom in California's Eastern District did something the American justice system has now done exactly 200 times since 1973. It admitted it was wrong. The man at the center of this admission had waited 41 years for it. He was sentenced to death in 1983 for 2 murders he did not commit, inside a prison where the only people willing to testify against him were other prisoners, men who, it would later be proven, were lying. His name is Larry Roberts. He is the 200th person in this country's history to be exonerated from death row. And his case is not just about one man's 41 stolen years. It's about a number the United States did not want to reach, a number it reached anyway. To understand what happened to Larry Roberts, you have to understand where it happened. Not just California, not just death row. A specific institution, the California Medical Facility in Vacaville, a prison that, despite its name, has long housed some of the state's most dangerous offenders alongside those receiving psychiatric and medical treatment. In 1983, Larry Roberts was already incarcerated there, serving time on an earlier unrelated conviction. He was not a free man walking into this story. He was already inside the system, which meant that when violence happened around him, the system already knew exactly where to look. That year, 2 people were killed inside the facility in separate stabbings: a fellow prisoner named Charles Gardner and a prison officer named Albert Patch. The killing of a corrections officer is, in any prison system, treated as close to a declaration of war. Investigators move fast, prosecutors move faster. And in an environment already primed to assume the worst about the men inside it, the question was never really, did Larry Roberts do this? The question almost immediately became, who can we get to say he did? The case against him would ultimately rest on one kind of evidence, and one kind only: the testimony of other prisoners. No physical evidence connecting him to the weapon, no forensic trail, no motive beyond what witnesses claim to have seen. Just men inside the same institution telling investigators what they said they'd witnessed. In 1983, Larry Roberts was sentenced to death, twice over, once for each killing. Here is what the trial record did not show the jury. Here is what stayed hidden, sometimes for decades. One of the state's key eyewitnesses against Larry Roberts later admitted, years after the trial, that he had lied, under oath. He told investigators that he had been pressured, threatened in his words, by the very people building the case against Roberts. Let that sit for a moment. A man stood in a courtroom, raised his hand, swore to tell the truth, and then told a jury exactly what investigators needed him to say because he was afraid of what would happen if he didn't. That wasn't the only problem. A second eyewitness, someone whose account also helped send Larry Roberts to death row, had been declared legally insane, not by one psychiatrist, by 3 separate court-appointed psychiatrists who all reached the same conclusion about this man's competency. The defense was never told this. This is the legal mechanism at the heart of Larry Roberts' case, and at the heart of the majority of American wrongful convictions. A 1963 Supreme Court ruling called Brady v. Maryland. It requires prosecutors to share evidence that could help the defense, evidence that might create reasonable doubt or undermine a witness's credibility. It is, on paper, one of the most important protections in the American legal system. In Larry Roberts' case, it was simply ignored. This is not a rare pattern. Of the 200 death row exonerations documented across the United States since 1973, official misconduct by police, prosecutors, or government officials was present in 70% of them. 65% involved false accusations or outright perjury. Larry Roberts' case checked both boxes. What does 41 years actually mean inside a system built around the expectation that you will eventually be put to death? It means appeal after appeal. It means watching the legal landscape shift around you. New precedents, new standards of evidence, new scientific tools, while you remain exactly where you started, condemned. Years into his sentence, the California Supreme Court did intervene, partially. It overturned Roberts' conviction specifically for the killing of the prison guard, Officer Patch. But his death sentence for the killing of the fellow prisoner, Charles Gardner, remained in place. A partial correction, not justice. Just enough doubt acknowledged to chip away at the conviction, not enough to free him. He stayed on death row. It would take more than 4 more decades, and a federal judge, not a state one, to finally, fully unravel what had been done to him. In 2024, the United States District Court for the Eastern District of California reviewed his case in full. The court's language, when it finally ruled, did not mince words. The judge found that prosecutors had suppressed exculpatory evidence that could have helped Roberts, that they had suborned perjury, meaning they had knowingly allowed false testimony to stand, and that they had presented evidence the court determined was simply unreliable from the outset. The judge went further. The ruling stated plainly that even setting aside whether individual prosecutorial actions technically rose to the level of formal misconduct, the trial itself was, in the court's words, fundamentally unfair, and that this unfairness had affected the jury's verdict. 41 years after 2 death sentences were handed down, a federal court said, in essence, this should never have happened the way it did. A federal ruling overturning a conviction does not automatically mean freedom. It usually means a choice for the state: retry the case or let it go. For the California Attorney General's office, that choice came down to a practical reality, laid out plainly in their own review. So much time had passed, 4 decades, that many of the original witnesses were now deceased. Others were of such advanced age that the state itself acknowledged they would be unable to meaningfully testify at a new trial. In the state's own words, a retrial was not, quote, reasonably feasible. Not because Larry Roberts was proven innocent in some dramatic final showdown, because the system had simply run out the clock on its own case. The same passage of time that had stolen 4 decades from Larry Roberts' life had also quietly erased the foundation the state would have needed to convict him again. On June 29, 2024, the federal judge formally granted the writ. On July 1st, the California Attorney General's office confirmed it would not pursue a retrial. Larry Roberts became the 200th person exonerated from American death row since the modern death penalty was reinstated in 1972's aftermath. It is worth pausing on this number because a number this size is easy to look at and feel nothing. 200 people, exonerated, not released on a technicality, not paroled, not granted clemency as an act of mercy, formally, legally cleared of crimes that, in each case, a court ultimately determined they did not commit. These 200 exonerations span 30 different states. Collectively, according to the Death Penalty Information Center's own analysis, these 200 people spent a combined total of over 2,600 years in prison conditions built around the expectation of execution. On average, that's 13 years each, under an active death sentence, before the truth caught up. Larry Roberts waited more than 3 times that average. There's a racial pattern in this data too, one the Death Penalty Information Center has tracked carefully across all 200 cases. 65% of death row exonerees are people of color. 54% are black. Florida has produced more death row exonerations than any other state, 30 in total, followed by Illinois with 22 and Texas with 18. Ray Crone, the man who became the 100th death row exoneree back in 2002, released a statement when he heard Larry Roberts' case had become the 200th. He called it, in his words, a bittersweet milestone. He said something else too, something worth sitting with, that in just 22 years since his own exoneration, his own walk out of prison as the 100th person cleared, 100 more names had been added to the same list. 100 more people in 22 years. That's not a system correcting a rare historical mistake. That's a pattern. Larry Roberts' exoneration did not happen in isolation. The very same year, 2024, brought his case, alongside several others that gripped national attention for entirely different reasons, because their outcomes were still undecided. While courts were correcting 4 decades of injustice in Larry Roberts' case, Texas was simultaneously scheduling the execution of Robert Robertson, a man convicted on the now widely discredited shaken baby syndrome diagnosis, despite new medical evidence indicating his daughter died of natural causes. In Missouri the same year, Marcellus Williams was executed despite DNA evidence that the local prosecutor's own office said pointed toward his innocence. 3 men, the same year, the same country. One walked free after 41 years. One was executed despite serious doubt. One remains even now fighting for a hearing that keeps getting delayed. The Death Penalty Information Center's own analysis, published after Roberts' exoneration, identified a troubling pattern hiding inside the celebration of reaching 200. The average wait time between wrongful conviction and exoneration has roughly tripled over the past 20 years. It is taking longer, not shorter, for the system to admit when it has gotten things wrong. In May 2025, nearly a year after his exoneration, California's Board of Parole hearings recommended that Larry Roberts be paroled, pending the governor's approval, into transitional housing, with the eventual hope of living with his wife, a wife who waited for 41 years, for a number the system did not want to reach. Larry Roberts is the 200th name on a list that should not exist at all. He will not be the last. If a case like this disturbs you, it should. The question worth sitting with isn't whether Larry Roberts deserved better. It's how many more names are still waiting to be added to this list, right now, today, and how long the system will let them wait before it finally listens. Larry Roberts is the 200th name on a list that should not exist at all. He will not be the last. If this case disturbed you, that's the right reaction. Cases like this don't get the attention they deserve, which is exactly why this channel exists. To tell them properly, one at a time. If you want to see how this story connects to others like it, the case of Robert Robertson is still unfolding right now, and it's linked at the end of this video. Subscribe if you want to follow where it goes next.